Good morning, everyone. I would like to have a conversation with you concerning one of the most commonly applied for visa category in the US, and this is called the Fiancee visa, also known as the K-1 visa. My presentation with you today will be broken down into three parts. First, we'll talk about the requirements. Second, we'll talk about the steps that the beneficiary needs to go through for him or for her to complete the whole journey. And lastly, third, we will talk about the timelines and try to understand how long will these steps take. First requirement, of course, you have to have a U.S. citizen fiancé. After all, this is a fiancé visa. It means that if you have a boyfriend or a girlfriend who is a green card holder, unfortunately, they could not file a fiancé visa. Only U.S. citizens can file a fiancé visa. So how do you prove that? You could use the petitioner's U.S. passport or U.S. birth certificate or the certificate of naturalization. Second requirement, personal meeting within 2 years from filing. It means that where the location the couple meet in person, that is not important. They could meet in Manila or Dubai or Hong Kong, anywhere, for as long as they meet in person. There's exceptions to this rule, but again, for purposes of this presentation, I will not discuss it here. Third requirement is financial capacity. Though you don't need to prove that in the first step, but you have to have that being considered when you are filing a fiancé visa because it could impact the approval of the petition. So for a general understanding of how much is required, if the petitioner has no one financially dependent on him or her, then he or she should actually earn $21,000 a year, and that's only for two people. It becomes complicated when the petitioner has children or some dependent people or some child custody or child support obligations, or if the beneficiary has children who are also dependent on her or him. So again, that would complicate the matter. And last requirement, and I would say the most important one, is the couple should understand that they don't have grounds of denial. And one of the strongest ones were criminal record. The criminal history could come from either the petitioner or the beneficiary. It could also involve from previous marriages where the primary ground of divorce is domestic violence. When either party is involved in felonies or serious crimes that involves prostitution or drug or alcohol related or murder, those kinds will basically be a ground of denial. I've represented cases with 12 convictions in the past, but I would say they are not easy, but they're challenging though. But again, have a conversation with a lawyer when you have criminal history. One of the grounds too that your petition could be denied is when either party has been involved in cases involving fraud or misrepresentation. Those are so serious offenses for U.S. immigration too. So basically, people ask me though when they actually have initial consultation, and by the way, I don't charge initial consultation, at least the initial ones. They ask me the question of, is it really required to hire a lawyer to file their petition? Generally, and I understand that one of the primary reasons why people are hesitant of hiring lawyers because they are quite expensive is money matters. And I understand that money is important to us and it's not easy to earn them. Those are one of the reasons why they would actually say we will try to do it on your own. But if your case is not as clean as others, meaning that you have issues with previous marriages including involving domestic violence, or if you've been involved into crimes especially with drugs, alcohol, domestic violence, DWI or DUI, I would recommend hiring a lawyer. Not all lawyers are expensive. Some are actually reasonable in terms of their fees. Other than that, people who have the time and have understanding of how this whole immigration journey, of course you can file on their own. U.S. immigration processes and procedures are designed to be applicant friendly for as long as you have the time to read from the right sources and try to understand what those requirements are, then you can file on their own. But then again, I would just like to remind that if your case involves criminal record or previous applications involving fraud, misrepresentation, talk to a lawyer. It would save you from whole stress of waiting for months, years, and then eventually you will be denied. And it could have been resolved at the earlier stage if you talk to a lawyer, especially when the lawyer actually offers free initial consultation. So take advantage of that. Second topic is steps. There are two steps in the fiancé visa. The first step is the fiancé visa itself, where the beneficiary needs to appear at the embassy to prove the relationship. There are other matters or factors that the embassy needs to look into during the interview. And that's the opportunity for the embassy officers to investigate whether or not the fiancé visa petition has been filed with a bona fide or a legitimate relationship between the parties. The embassy will also look into the genuinity or whether or not the documents submitted are genuine and not fake. And the U.S. government is very good at that. Once you have the first petition approved at the U.S. embassy, the beneficiary will receive their visa or passport back with a visa stamp, generally within 1 to 3 weeks, depending on what embassies they are looking or they are applying or appearing to. After that, they could fly to the U.S. And for fiancé visa holders, they are required to get married within 90 days from the time they arrive in the U.S. Is it required that they file their green card, work permit, and travel permit within the 90 days? The rule only requires that they get married. But to avoid complications and issues later, it is generally and highly recommended that the couple file for their green card, work, and travel permit from the time that they have copies of their marriage certificates. So that's the steps that they need to go through. Generally, the beneficiary will receive a conditional green card, meaning the duration of the green card will initially be 2 years, and then 90 days before the expiration of the 2 years, they will need to apply for the removal of condition. That's the time for the government to investigate of whether or not the couples are legitimately living together as husband and wife. Again, there are exceptions to that. I'm not going to discuss it here to simplify the whole conversation. Last category that we would want to talk about is timeline. How long does it take? The first step, meaning the filing of the fiancé visa petition up to the time of the embassy, could actually take from 5 months under normal processing, then another 1 to 2 months to transfer the case from USCIS to the National Visa Center to the embassy. Luckily though, my earliest record for fiancé visa is 11 days. And sometimes that's a blessing and sometimes a disadvantage, because people now are looking and calling you that, hey Nick, my petition has been filed now for 12 days and we haven't heard anything. I'm not promising them that. The normal processing for fiancé visa is 5 months. My average record is around 1 month, 2 months I've been approved. And then it would take another 1 month to 2 months to transfer the case from USCIS to the embassy. So under normal processing, you will be expecting 5 months of review approval at the USCIS level, and then another 1 month to 2 months to transfer the case from USCIS to the embassy. Then once they are already in the stage 2, which basically is the green card application, generally the green card application or the green card should have been issued 6 months from filing, but there are a lot of reasons where that green card issuance will be delayed. It could involve reasons beyond the control of the lawyer or the applicants themselves. So it should not be an issue for as long as you have your travel permit or work permit applied or filed together with the green card. It means that they could travel in and out of the U.S. They could work legally in the U.S. They could apply for their social security number if they actually have the work permits. Now, applying for the social security number depends on the state where they live. Each state prescribes their own requirements, so they just have to talk to or visit the nearest Social Security office once the beneficiary is already in America and inquire what those requirements are. Okay, so I actually just covered the three major steps of the fiancé visa. So I've talked about the requirements. Again, I would just like to summarize them. You have to have a U.S. citizen fiancé. You should meet in person within the last 2 years. The petitioner should have the financial capacity to petition. The last requirement would be there should be no ground of denial. Steps: first, application fiancé visa to the embassy. Once you got that visa and the person beneficiary is already in the U.S., he or she needs to file for the green card, the work permit, and the travel permit. Timeline-wise, fiancé visa would, under normal processing, takes 5 months, then another 2 months to transfer the case from USCIS to the embassy, and then the green card process generally takes about 6 months. Again, thank you everyone. This will be the start of me sharing knowledge about U.S. immigration. If you have other questions, please visit www.idream-america.com, and you can contact me through email or text messages or whatever means. For people who would want to talk to me through phones, I really am sorry if I could not accommodate direct calls. You have a better chance of being able to contact me if first you would send an email to me through my website and try to explain to me what your situation is, so I could initially review them, and after that we could agree on when, the date and time, or we could actually talk about your case. And again, I don't charge initial consultation fees, so looking forward to talk to you soon. Thank you. Bye-bye.